And Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
Excuse me while I get my file, please.
Okay, we're going on. Let's see. Would we're going on all of the counts, it looks like.
Yes, to enhance.
With our take this. I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions, a state jail felony November 8th of 2021. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And how do you plead to that charge?
Yes.
And are those all of those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
And I think.
Okay, and then we have clause number 26, DCCR 0140. And, sorry.
Right away, you can tell this is not a first-time offender situation. Prosecutors are stacking prior convictions here to enhance the current charges, which dramatically increases a potential prison exposure. In Texas, repeat theft convictions can quickly escalate from smaller offenses into serious felony territory. And notice how calm the courtroom sounds? That usually means the plea deal has already been negotiated behind the scenes before the hearing even started.
And in that case, you're also charged with the state jail felony offense of theft of property with previous convictions. And that one is from December 16th of 2025. The indictment alleges the same prior theft offenses, the 2 from May 18th of 2018, and then the last one from December 3rd of 2021. And then it also alleges those same prior 3 state jail felony convictions. And how do you plead in that case?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are those prior convictions all true?
Yes, ma'am.
And then finally, we have 26 DCCR 0274. And you are charged in that case with evading arrest or detention with previous convictions from January 21st of 2026. It alleges that you were previously convicted of evading arrest or detention March 13th of 2017 and also November 8th of 2021. So this one does not list those other priors. So it just is a state jail.
Yeah, it's supposed to.
And I apologize. I didn't notice that it didn't list the other priors.
We don't object to an amendment if they,
Now, the state would ask to amend.
I'm not writing all that in.
you want to dismiss that one?
I mean,
That is the,
evading arrest or detention with previous convictions.
I hate dismissing and evading.
I mean, I can reset it. Y'all can file an amendment, or if you want to write it out. But that's too much for just an amendment. That's 3 prior offenses. So whatever y'all want to do. Y'all want to talk about it for a minute?
I can write them out if I need to be consistent.
This is one of those moments courtroom watchers love because you get to see the legal machinery stumble in real time. The prosecution forgot to properly include enhancement allegations in the indictment, and that mistake could have weakened the case significantly if not corrected. Defense attorneys pay very close attention to errors like this because procedural mistakes.
Why don't you do either handwritten or typewritten if you want to get down here real quick, a notice of to enhance with those 3 in it, and then I can read the notice to enhance.
I'll do
Okay.
that very quickly.
I'll hold it.
Thank you.
All right, sir, you're Jabbar Bell again, right?
Yes, ma'am.
And so we're back on clause number 26, DCCR 0274. And in that case, Mr. Bell, I'm going to start from the beginning. In that one, you're charged with the state jail felony offense of evading arrest or detention with previous convictions from January 21st of 2026. And the indictment alleges you were previously convicted of evading arrest or detention March 13th of 2017, and then again November 8th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Now, Mr. Parker, the state has filed a motion asking to amend the indictment to include those 2 prior offenses that we've already gone through and read in the other tech cases. Do you have any objections? And you will waive your any time to review that, correct?
Yeah, Judge.
So, Mr. Bell, the indictment, I'm going to grant the motion to amend the indictment. Further shows now that you were convicted previously of unauthorized use of a vehicle, a state jail felony, June 24th of 20.
Here is the critical legal pivot. The defense technically objects, preserving the issue on record, but then agrees to waive extra review time so the hearing can move forward immediately. That usually signals there's already a negotiated agreement both sides want to preserve. Once a defendant waives additional preparation time.
2019, and after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And are those prior convictions true?
Yes, ma'am.
And in all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find in all of your cases that you entered your pleas of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. And cause number 26, DCCR 0139, find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find all of those prior convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the.
And there it is, the formal conviction. Notice the phrase, in accordance with your agreement. That confirms this was a plea bargain rather than a surprise sentence from the bench. The judge is essentially approving a deal negotiated beforehand between prosecutors and defense counsel, considering the long criminal history listed here. A concurrent 4-year sentence may actually have been viewed by the defense as damage
Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in.
Judge West finds the defendant guilty on all charges, upholds the plea agreement, and sentences him to 4 years in the Texas Department of Corrections, with all cases running concurrently.
That you've been in custody that the law gives you the right to receive. And then, excuse me, clause number 26, DCCR 0140, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find all of the prior convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26 DCCR 0274, again, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. Find all of the previous
A lot of viewers here for years on 3 cases and assume that means 12 years total. But because the sentences run concurrently, he serves them at the same time, not back-to-back. The judge also reminds him he waived most appeal rights as part of the plea deal, which is extremely common in negotiated felony cases, and that firearm warning is not just routine paperwork. Violating those
convictions that you pled true to true, sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 3 of these cases will run concurrently, which means together at the same time. And I'm going to hand you in all 3 cases the trial court certifications that shows that these were agreements that I followed, and so you waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. Thank you, Ms. French, for getting that taken care of, and Mr. Parker.
At the end of the hearing, Judge West delivers the final ruling after the defendant pleads guilty in multiple cases involving theft and evading arrest. The court accepts the plea agreement, finds him guilty on all charges, and sentences him to 4 years in the Texas Department of Corrections. All sentences will run concurrently, bringing the case to a close.